Call the member for Morini.
Deputy Speaker, I rise to speak on the Local Government Electoral and Other Legislation Expenditure Caps Amendment Bill 2022. According to the bill's explanatory notes accompanying the bill, there is a concern for potential inclusion of costs for office accommodation and paid campaign staff which have not been included in the legislation. I noted in the Oscar submission that there have been incidences where, for example, a landlord supplies commercial office space to a candidate but does not charge commercial rent, and this should be declared. Similarly, if candidates have campaign staff in said offices, they should also declare any payments to them. In local government elections, it would be fair to say that very few candidates would have election offices where either a mayoral or councillor candidate has office space during an election. This should be declared as it is either being funded by the candidate's election funds or is being provided as a gift, part or full rent for the term of the election. An example of such is where a shopping, theatre, office centre owned by a developer allowed a candidate office space for more than 12 months leading into the election. Under the ban on developer donation, such approval would now probably be given by centre management. Avoiding the developer ban, the amount of rent paid, if any, was never disclosed to the electors. It is evident that this expense should be included in the cap for electoral expenditure. Similarly, most candidates in local government elections have volunteer staff where paid staff are used that should also be declared. An alternative may be allow any candidate to have undeclared office accommodation and or staff for the period from when the election is called until election day. By not including accommodation in the election expenditure cap immediately, the candidate availing themselves of such opportunity has a clear advantage over the candidate operating from their home. A similar advantage applies the use of paid staff. It can be seen that the bill is encouraging more party political and groups of candidates nominating for elections as opposed to genuine community independent candidates. Speaker, the individual mayoral cap amounts for larger councils and the timing of applications of expenditure caps is another issue that needs to be addressed. The Department of Local Government, Racing and Multicultural Affairs proposed a maximum figure of $100,000 for mayoral candidates, while the local government, or the LGAQ, proposed a figure of $200,000 for mayoral candidates. These amounts make it unaffordable for most potential candidates and result in only wealthy and very well-funded candidates to contest mayoral elections, with any expectation of being successful. For the majority of candidates, election spending for the 2020 LG election was significantly lower than the caps currently proposed. Again, Mr Speaker, Oscar's submission highlights an unintended consequence where more party-aligned candidates standing for mayoral positions take advantage of financial support from their political party. Local government should be free of party-endorsed funded candidates. In addition, Brisbane Residents United submissions shines a light on the lack of regulation for industry associations and corporations. These are the biggest players in Queensland elections. A closer examination into ways which corporate income is used on electoral expenditure could be restricted or at very least disclosed transparently. I have serious concerns over third parties that can embark on media campaigns to further their cause or to run a negative campaign against a particular candidate or group of candidates. Speaker, there is no legislation to address the revolving door between industry and government which leads to inside relationships without due regard being given to the public interest. As outlined in Queensland Law Society submission, the concern that the current bill will have a chilling effect on participation of not-for-profit and charity organisations in the debate and the development of social policy. The amended drafting reflected in this bill introduces a number of additional uncertainties about the scope of the third-party registration framework due to the following concepts. Section 109A, 5 and 6 of the LGEA could be left to the court's interpretation to decide when the purpose of the third-party expenditure is needed, electoral expenditure. The proposed section 109.81c of the LGEA suggests that the third-party expenditure could be considered expenditure for a campaign purpose even if there is no mention of a particular political party or candidate in the material produced. QSL is correct. This legislation will restrain and legitimate and valuable voices of charities and not-for-profit organisations in political discussions and debate because of an organisation's fear of inadvertently advocating in a way which is perceived to otherwise influence voting at an election. This risk is highlighted under this when under this bill, it does not matter if the material in question does not even mention a particular party, candidate or group when the position is expressed. Community groups are well placed to identify issues of concern and should be encouraged to create community conversations to make change on matters that affect them, i.e. rates, land valuations, cost of living, social issues like domestic violence, health and all other members of material stuff that we actually go through in these elections. The bill should be renamed the Non-Local Government Bill. It is one purpose is to eliminate independent councillors and replace them with party members, I feel. And the way the allowances and wages are set up, only party groups can be capable of organising their way into council, which is a damn shame. Independents have always been the way local government operates. They're local, and because of that, they know more about our local issues and the solutions to fix them. Party tickets, as favoured in this bill, just don't get the same results, and they cost more, especially when the elected mayor is in conflict with the majority of elected councillors. Another situation is the situation with the committees and the introduced legislation this morning, or the amendments. I've often said in the past that we should use the crossbench as the actual casting vote as the chair. It always makes it a more fairer and democratic process for this establishment. That's always going to be a difference in opinion, but at the moment it's heavily weighted for bias as far as a democratic purpose is concerned. I feel, in my opinion, there would be a nice way of being able to go the other way and actually give some of the actual crossbench members an opportunity to be the chair of the committee and to give us that situation to be able to make sure legislation that comes through.
Member Ferrani, I'll draw you back to the bill, please.
Thanks very much, Chair.
Speaker.